Hey, Brian Parker here. I am back with another fantastic video. I always say in my membership site and when I email members or potential members, if you got a video request, let me know. It helps me, it helps you. So a couple of people have said, hey, I'm answering discovery. I have no idea what I'm doing. Hey, join the club. But that's not, I kind of know what I'm doing now after 30 years of doing this. Our membership site, of course, is collectionstoppersolutions.com. Like, love, and subscribe with this video. You'll notice a difference if you've seen my videos. I always mention Cindy. Hey, Cindy, Shazam, Cindy. I made her put her name and her production company on this. So you'll see that at the beginning and the end. But the word today for the video is show notes on answering discovery requests. This is how I do it. I will caution you that I'm a little off the wall after doing this, either because I've had enough or because I can see where somebody's going and how hard they will push. Those nuances are not part of your repertoire. So act accordingly with what I tell you to do. If it makes sense, fine. But put everything I tell you through, here I love this word, the prism of your state rules, state discovery rules. They're all pretty much the same. They somewhat mirror the federal rules, but again, everybody has their quirks. So if I tell you something and it's sort of, just keep an eye on as far as objections go and how to answer or how not to answer, look at your state rules. They all have the same premise. You've got to be truthful, of course. If you're going to cite an objection, make sure there's a basis of that objection. And also, in a lot of states, at least with interrogatories, you have to sign it under oath, whereas maybe not request to admit or request to produce. I have a thing where I have my clients sign everything under oath, so there's no question as to anybody telling the truth. And you're going to learn today about, again, this word flatlining. When you get these discovery requests, you are going to open and go, are they kidding me? I am not telling them what my job was 5 years ago. Or they want to know what? They want to know about my husband. So I want you to flatline, no matter how upset or angry, because you don't have the burden of proof, they do. I want you to flatline and go, okay, let me take a look at this. So I'm going to give you responses, the rationale and reasons why I do what I do. And then in response to that, the person that asked for a response to discovery help, this will be it. And what I'm going to do is I'm going to add several word template responses I've used against velocity, accredited discovery. I think there's some student loan discovery. So there's lots of stuff that you can mirror. Remember the premise of your defense when you're doing these things. They have not shown proof that you own the debt. There's a reason why I'm telling you that. They have the burden of proof. You're not there. And this is what happens. This happens all the time. These interrogatory discovery request questions, and they're normally in the three forms: request to admit, request to produce documents, and interrogatories. You can see that they're asking for help to beat you. They're asking for information that can only hurt you and help them. So I have this thing that I'm doing that I'm going to show you. If you look at my one of my templates, it's against Rock Creek. I sort of had enough, and they clearly didn't own the debt, and they were fishing for information to prove that their case is good. So there's an example on there. I will show you what I did. You know what? I'm going to do it right now. Cindy, put up how I responded to request to admits as to the above requests to admits 1 through 26. Shazam. And that is what I'm telling you as far as the premise of your defense and your counterclaim. The counterclaim follows wherever you go. The premise there was, I deny everything. So you can sit there and when someone sends me 26 requests to omits, I'm calling bullshit on that. They're not looking for anything other than to hope that I forget to file a response. And with the request to omits, generally you have 28 days to respond. And if you fail to do that, everything they asked you is admitted. And that makes their job easier. Again, that's what I'm talking about. They don't want to have to do the work. They want you to do the work. So you can see that response. I just said no to all of the above. And why? I can't really do that. But I can if I have a good faith reason backing up either my denial or my admit or my objection. And you can see where I said they failed to provide any proof of ownership of the debt or meet its burden of proof without showing any assignment from the original creditor. So I wrote, please see Exhibit 2, Exhibit 3, the answer. So I have said no. And it's based on the fact that I don't have to answer a darn thing if they haven't met their burden of proof. And until the case is over, they haven't. So we'll talk about what they will do in response to something like that. And by the way, that case got settled. So please know your state and federal rules in your area. There's a great movie, Howard Stern movie called Private Parts. What am I saying that for? Because I want you to remember private parts. By the way, I'm reading from show notes. They will be attached to this video along with several Word templates of responses to discovery you can use. So, private parts. The premise of a lot of responses in my documents, if I sense or smell or see they're asking for private information, I immediately say objection, identity theft, and then I'll add this. I go, I am not giving my private information to a debt collector. That's my response. So private parts, remember that. You look at my show notes. The ID theft case, if you're being sued and it's an ID theft case, just say no. Because you don't own the debt and you filed your police report, your proof that you don't. You shouldn't have to do all this work. ID theft cases are just so frustrating for me. The person has to pay me money, has to do all this work, answer discovery to prove something that is a negative, meaning you didn't do what they claim you did and now you're being sued for it. But you've got to do all this work as an ID theft victim. So just say no. Again, any discovery request of you must be reasonable and relevant. There's a big leeway there. It used to be everything is relevant. You could make everything relevant. What color is the sky? How is that relevant? Well, at the time you took the debt, blah, blah, blah. So I'm being facetious. So look at the rules. Know how you can object. My number one objection is relevant. How is your seeking information from me on a debt you don't owe relevant to what job I had 5 years ago? You're a debt collector. You're just going to use that information to come after me. So, but you must have a good faith basis for your objection. My other favorite is in regards to they're not proving they own the debt, an objection called facts are evidence, facts not in evidence. A lot of their questions are premised on something that, for example, when did you take out the debt? Well, if I'm an ID theft victim, I didn't. Objection, facts not in evidence. If they're claiming you owe them a debt and there's no proof you do, objection, facts not in evidence that you own the debt or have the right to ask that question. I'm going to tell you where these objections and waivers go. Coming up in the video, I'm going to show you how I do these things as far as the premise. Now remember, when I say the premise, I'm required to do this every video. Where do the documents come from that go into your counterclaim? Where do they come from? Where? That's right again. Their own documents. So you base your responses on their own documents. And if there's no chain of title, say that in your response. Most collectors, when you respond, here's a little dirty tip, and it's true. I'm going to say 99% of the time, you will not see a debt collector follow up on your response. So you've filed your answers, you've done your objections, you've maybe given them a couple of answers, names, and all this stuff, and you've really kind of crossed the line or stayed on the fence but not committed to anything. Where if, for example, I got something that was BS, I'm going to push and ask for supplements. Debt collectors won't do that. So get an answer in and you'll probably never see anything. Once in a while, you will face a motion saying, hey, he didn't respond as well as he should within the court rules. I love that. Why would you want to be facing a motion? Because if you believe you're right and your response is, I don't own this debt, why would I respond the way you're asking me to? It's a free shot for you to appear in front of the court and give your counterclaim response again. So I like it when I face an attorney that isn't keeping his eye on the ball and he's like, I'm going to file a motion. I think in my head self, if I'm right on why he's filing a motion, he's giving me a free shot to go right in front of the judge and go, yeah, Your Honor, remember this case? It's about them not owning the debt. You'll see the broken chain is blah, 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 blah. Before he gets a chance, now he's on the defense with your defense, and he gave you the free shot. So don't be so scared of motions to compel you to make better answers, which you're rarely going to see, okay? If you don't want to answer something, you can file a motion for a protective order. Again, follow your state rules, but that's a great motion, A, to yell about your defense, and they made you bring it in by giving you 26 requests to omits, which aren't necessary, so slap them back. And the judge is probably going to go your way because most debt collectors, and I see this all the time, send out the same 26, the same 30 requests to omit, requests to produce, the same 50 interrogatories, meaning I will defend against the same defendant and the same law firm will send me the same stuff. So I'll literally just give them the same answers, change the names. That's it. And no one says a thing. Once in a while you throw something in there where it's sort of hokey just to see if they're reading, and they're not. They're billing more than they're reading. So don't be afraid that, oh God, they're asking me all these questions. No one's reading your answers. Unless it's a real serious case, no one's reading your answers. But again, make sure you do everything safely and by the rules. So I just said earlier that when you respond, this could be a really boring video, so I'm going to just go fast. But people want help, so I'm going to give you the video. It used to be everything is relevant. Everything is relevant. The questions they ask, they're relevant because they asked them. Now states, especially as a federal model, are going on what's called proportionality. And here it is. The requesting party must now demonstrate that its discovery requests are both relevant, of course, and proportional to the needs of the case. So why are you filing 26 requests to omits on a $5,000 collection lawsuit? That's not proportional to the needs of the case. In Michigan, for example, they say, and this is you filing a protective order, to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. By the way, those are objections. Those are objections that you can put in your answers. And that's based on Federal Rule 26, which I don't like to mention federal rule because we don't work in federal rule, but that's something that all states are following now. And they look at the importance of the issues at stake, the amount in controversy, the party's relative access to relevant information. So they're asking you to go, hey, give us your paycheck from 5 years ago. There's no way you can get that, and why should you? A lot of my answers with requests to produce are, sorry, I don't have it. Because these days we purge everything. So you can legitimately say, I know, every year I purge everything. And of course, the real concept is the burden of expense or the proposed discovery outweighs its likely benefit. So as a non-represented person, you can always say, this is too expensive and I just don't have the energy to do this. But here's another way to do a motion for protective order. Good, strong objections that, by the way, are not going to be read. And that is a motion for protective order because they have to file a motion to get you to answer something they say you should have told them. Again, that'll resurrect them filing a motion to make you answer. And you can just say, okay, I'll have the judge decide and I get my free shot to tell her what this case is all about. And you may just win. Again, remember, when you're filing an objection, have a good faith basis. Objection, relevance. I don't own this debt. I'm a victim of ID. Attach C, my answer, my affirmative defenses, my counterclaim, and the police report. No one's forcing you to answer that question. And you can pretty much have that the basis of most of your responses. And again, no one's really going to get back to you. Your only thing that you should be wary of is request to admits. Debt collectors will send you BS request to admits, making, you could just say objection no or denied, or, well, you have to say either admit or deny, or you don't have the information, but each denial or objection or lack of information must have a good faith basis that you pronounce. You're cool there. But the only real good reason for sending requests to admits is to hope that you as a non-represented person will not answer in 28 days, and that commonly happens because you're not familiar with the rules and everything, and you feel overwhelmed. That's why I want you to remember flatlining. Be a flatliner. Don't take it personally. Some of the stuff they ask, it seems personal. Be flatline. Don't get high, don't get low. Just respond. When the other side goes low, what do? We go, no, we just respond. Just respond. So look out for request submits. The interrogatories and request for production, in a lot of states, no one's sanctioning you for automatic admission if you don't answer them, but just keep an eye on those. But the request to admits, they get special attention because they're really just filing, hoping that you miss the 28 days. So I'll give you a couple of examples of how I respond. Just a couple of examples. Again, remember, attached to this video will be a lot of responses that you can take a pic of this and this. If it's a creditor response, or it's for discovery, or a debt buyer, or a student loan. They're all on this video. So let's put the first one up. Cindy, Shazam, please produce all documents to manifest that your allegation that you did not request an online loan from plaintiff or the plaintiff's predecessor in interest. I love that question. Why? Because who the hell knows what they're saying? So I write, objection as to manifest, as I don't know what you are saying, and further, objections or records or facts not in evidence. So I'm telling you what I do, I just showed you what I do, right? Anytime you have a request that you don't understand, and it's good that you're not an attorney, it really is, say so. I can't answer this. Why? 99% of the time, they won't follow up. So if it's a truthful response, I don't understand what the hell you're saying. Don't be that human, but the way I just said it is as human as I could be for you, that you won't have a follow-up. 99% they don't follow up. Here's another one. Cindy, number 4, Shazam, please submit a copy of your driver's license. Response is, defendant objects the request for fear of identity theft request and relevance to Velocity without further precautions as the debt is owned by someone other than Velocity. So it's a free shot for me to take a free shot. Not going to get anybody saying, all right, I'm filing a motion. You're saying, hey, I've already had my identity theft stolen once. I'm not giving them anything. So, and this is talking about as far as the expense of you having to go do all this work and respond to them. Cindy put up number 5, Shizmansky. Please submit at least 5 canceled checks that contain your signature. Up your beep. Response, I didn't say that. Defendant objects to the request for fear of identity request and relevance to Velocity without further precautions. So I am not doing that. I am not making my client go look for 5 canceled checks because she's probably purged them or never had them in the first place. See every electronic thing we store for maybe a year. So I told you about the Rock Creek response to request to omits. I have answered the request to omits, all 1 to 26 of them, and say deny. Just see my answer. And that is, when you look at the attachments to the video, they omit that. The answers I have are really there for you to pick and use in your responses through the prism of the state court rules and objections. So find out what objections you're allowed to do. It's going to be relevant. It's going to be proportionality. It's going to be facts not in evidence. But you can use mine as a guide. Someone said, hey, how do I answer these? You've got word templates now attached to this video. It's a boring video, I know, so I'm going to cut it short. If you need more help, let me know. My great membership website's got everything to fight the collector monsters and for you to be a warrior. So like, love, and subscribe to this video and my YouTube channel and my membership website, which is awesome. It's got like 180 videos and tons of word templates on everything and every collector and every creditor. Oh, guys, I'm supposed to say it. collectionstoppersolutions.com. All right, it was short and sweet, but it probably isn't. My show notes are on here too to help you along. I hope this helps. It's admittedly a rudimentary or a kind of surface approach, but you're going to be better off than doing this on your own. I'm crazy, but I follow the rules. You should too. All right, thank you very much, and I hope the video helps. Brian Parker.